and it builds our case, and it makes it even a better case than it otherwise might be. I want to speak to you briefly about safety provisions in contracts. After all, we're dealing with the Safe Place to Work statutes. As a plaintiff's attorney, what you want to show is obviously, in general, that your injured worker was not given a safe place to work. And let's forget 240 cases for a minute. I'm talking about 200 cases, 241-6 cases. If I have, for instance, a worker who, for example, tripped over a carelessly left piece of electrical conduit pipe and had a severe enough injury for me to take the case, I don't want to present that case to a jury as a case in which one piece of electrical conduit pipe may have been left on a passageway, because I know any good defendant's attorney is going to point out that this isn't a living room, it's a construction project. And incidentally, if you handle these cases, go walk some jobs. Understand what goes on at these construction sites, because you as a defendant's attorney have to convey that to a jury, that certain things have to happen at these job sites. Conversely, as a plaintiff's attorney, and it's harder to get on the jobs, but you can walk around the city and look through the holes and look in there and see what's going on, become conversant with. It's no different than a medical malpractice case, where if you're going to do it justice, you have to sit down and know that one area of medicine as well as the doctors that you're going to be cross-examining. If you're going to handle these types of cases, you got to know the lingo, you got to know the jargon, all right? And there's plenty of places to go get it. And if you have certain pieces of equipment that are involved, et cetera, you can learn about them. If you're in the city, you can go over to the engineering library on 47th Street. They'll let anyone in, and if you want to take books out, you can get you can join it. It's very cheap, and you really can learn about this stuff and become an expert in whatever given area you happen to be working on. In any event, if I have a 241-6 case like that, where I have to show negligence of someone to hook in the GC or owner or construction manager, as the case may be, I don't want to show that one piece of electrical conduit pipe was haphazardly laying about. What I want to show is that this was a haphazard, sloppy, carelessly conducted job where safety was of little or no concern. That's the picture I want to paint for a jury, because it's going to get them angry and it's going to maximize my damages. All right? And that's what I want to do. Now, how am I going to do that? First thing I'm going to do after I start discovery is I'm going to get the contracts. And what I'm going to see in the contracts, whether it's a contract between an owner and a GC, or an owner and a construction manager, or the subcontracts, are these safety provisions. There's a form contract in the course book at page 262, which has some of these provisions. And in my outline, which I believe starts at page 265, you'll see some of these safety provisions in a contract. These are very general provisions. They say things like there shall be safety programs which contractors shall comply with. Contractors shall comply with OSHA, the Construction Safety Act, etc. As a plaintiff, what you have to do is ask specific questions about what was done to implement the contractual provisions regarding safety. And you're going to find, at least in the cases that I've handled, that the answer is going to be often, not much, but what are you going to do? You have to know what to ask. You're not just going to ask open-ended questions. Well, what did you do about safety? You have to know. So again, you must know the jargon. You must know the trade. Conversely, as a defendant's attorney, certainly an attorney who's representing owner or contractor prior to these cases, when a job's getting started, it's not enough, I would submit, to put these general safety provisions in a contract with no method of implementation. If you're advising a contractor, you got to tell them, how do you implement these things? And you have to understand, in this day and age, we've had a total evisceration of OSHA since the Reagan administration. OSHA it's not that effective anymore. Budget was cut, and there was a governmental policy of not interfering, and that's what happened with OSHA. And as far as amending the labor law, and I know this bill is pending up in Albany, instead of amending it, it would seem to me, and we're talking about philosophical differences perhaps, but it would seem to me that cohesive safety programs should be implemented which will put into effect these vague responsibilities which are set forth in contracts. So you got to know, what is a cohesive safety program? As a plaintiff, I want to know what it is because I want to ask if it was done.